Today, we're discussing the referendum concerning the acquisition of citizenship by naturalization. The Constitutional Court has declared the popular referendum proposal admissible. Following the decision, voting will be held between the 15th of April and the 15th of June. It is important to remember that the Italian Constitution provides that the proposal subject to referendum is approved if the majority of the eligible voters have participated in the voting and if a majority of the votes validly casted has been reached. Law 352 of 1970 also stipulates that the same question cannot be reproposed for 5 years in the event that the vote passes the validity quorum, which is 50% of the participation in voting, but a no vote prevails among the votes validly casted. This would mean preventing the proposition of another referendum on rules concerning naturalization for at least 5 years. Even the abstention of more than 50% of the eligible voters would have an important political significance, because it would mean that Italians are not interested in reforming the discipline on access to citizenship by naturalization, which is the one most directly linked to the integration and inclusion of non-citizens legally residing in the territory, the so-called regular migrants.
Let's start with our discussion on citizenship issues and in particular on access to citizenship. We decided to speak about this topic. Why, Lisa? Why we decided this?
Because at the moment we have a constitution reform, a proposal of reforming the law, the actual law on citizenship in Italy, and today the Constitutional Court will decide about the admissibility of the referendum. So today we'll know.
We will know if we are going to vote on a referendum concerning what?
Abrogates, that means cancel, a part of a specific article of Italian law on citizenship, the law that we use to access to citizenship in Italy is the law 91 of 1992, and the referendum want to abrogate definitely two parts of Article 9. Mm-hmm. And this will change.
It is about
naturalization.
Naturalization.
Yes. It will change some criteria about naturalization. So the main point is to diminish the period of legal residence required in order to ask for naturalization in Italy from 10 years, that is the normal criterion now, to 5 years.
Okay. Do you know what is the impact of this reform? So what can happen if the referendum will pass?
The foreseeable impact is that about 2,300,000 people could access naturalization easily in 5 years instead of 10 years. And that means that because we ask for, when a foreigner asks for citizenship in Italy, you ask after a certain period of legal residence, that, for example, now 10 years. It will be 5 years if we can vote for the referendum and if a referendum
is approved.
Mm. After the request, the procedure is quite time-consuming. Normally, it's from 2 to 3 years. So at the moment, acquiring citizenship by naturalization in Italy can take almost 12 years, 13 years.
Yes.
If the referendum passes and we change
this
the
time
law,
will be reduced,
halved, so
okay.
8 years probably, and this could have a great impact also on children of those people, because basically our law doesn't deal with
immigration,
with second generation.
Can you tell us why do you think that Italian legislation is not capable of manage migration issue?
Okay.
Are there historic reasons or other kind of reasons? What do you think?
Historically, the actual law is very in continuity with the oldest law, which was a law enacted in 1912 that lasted up to 1992. So it was
very long time after also the entry into force of the Italian Constitution.
Yes, so because it was enacted when Italy was a monarchy. Then we had a lot of things in Italy, because we had fascism, and then Italy became a republic, and then we had the enactment of the Constitution. And Constitution basically changed some part of this ancient law because
because this ancient law was based upon what?
Ius
Which
sanguinis.
criteria? So ius sanguinis,
Yes.
single
Yes,
citizenship.
ius sanguinis, single citizenship. With
And
some
was there
exception.
some discrimination
Yes.
between
Gender?
so gender issues there were,
Gender
because
issues.
there was discrimination between men
And
and women in
Yes.
transmission of citizenship.
And there were also many automatism in loss
Of
and
citizenship by
acquisition.
marriage
Yes.
also. And what happened in the 90s? So we enacted our actual law is a law of 1992.
Yes.
What happened there?
Okay, the period between the half 80s and the 90s was a period very interesting in Italy because we started speaking about European integration, and at the beginning of the 90s, European citizenship, EU citizenship were born basically. So now we have another pieces of the jigsaw, so to speak, of the puzzle. So we started speaking about citizenship also because of this issue.
And what about naturalization?
For example,
With this reform of 92.
for EU citizens, we put a requirement of 4 years of legal residence.
So we facilitated naturalization of EU citizens,
Yes.
and on the contrary, for third country nationals, for non-EU
Yes.
citizens,
It became a bit more difficult because
Harder.
because before was 5 years of legal residence in the previous law. In the actual law, it's 10 years of legal residence.
Okay.
So
So basically, this referendum is a sort of return to the
Yeah.
past, to the legislation of the 1912. And this, do you think this is better to migration management, or is worsening the situation?
It's an attempt
It's an attempt to deal with it.
Yes.
And are there some other ideas of reform that were discussed, were debated over the years?
Yes, immediately after the enactment of the actual law, many bills were proposed to change the law because it was immediately clear that this law was unable to deal with the immigration issue. So the interesting thing is that during the 30 years since 1992 to now, to nowadays, many different
Proposals were
attempts were made. We didn't speak about pure ius soli. That means that you, if you were born in a place, you acquired that citizenship. We stick with ius sanguinis as a main criterion. But we spoke about, for example, temperate ius soli, where you can evaluate in a different way the permanent resident of parents, of foreign adults, for example, or, for example, ius domicili, which is more or less the same thing, and that was normally drawn upon the idea of the directive about long-term residents.
So like ius domicili aims at facilitating
Yes.
acquisition of citizenship for people that have a long residence permit.
Which is that you can acquire after just 5 years in Italy.
And what about ius scholae, ius cultura? What is the meaning of those words?
A child born in Italy, or a child who arrived very young in Italy, or a child that arrived as a minor in Italy can acquire Italian citizenship after the completion of cycle of schooling. So the primary compulsory education, for example, ius scholae, or also acquiring secondary diploma in Italy, or a professional degree. So all these methods are methods to acquire.
But the Italian Parliament never passed
No.
a reform introducing those criteria.
No.
Okay, thank you, Lisa. And now we want to cover also Ukraine. So what is happening in Ukrainian legislation about citizenship status? So because Ukraine is a country that gained independence from the former Soviet Union, and now there is a conflict with Russia, and there are a lot of issues, very important issues concerning citizenship in Ukraine. What is the main criterion that you have in Ukrainian legislation for acquisition of citizenship? The main criterion?
The main criterion in Ukraine for acquisition the citizenship, we are use sanguine.
Use sanguine, so it's like the Italian legislation.
Yes, yes.
And do you have the possibility to have double citizenship or not?
Not. In Ukrainian legislation, we don't have the possibility to have double citizenship. Only single citizenship. Single citizenship. It is a problem for Ukrainian
Why
people.
is a problem?
Because we have now 7 million citizens of Ukraine abroad. These citizens acquire the citizenship of other states or are acquired citizenship other states whom provides them for temporary protection. Don't acquire citizenship these states because the law of Ukraine don't have this possibility.
So they could lose the citizenship of Ukraine if they acquire another citizenship of another state. And what about Ukrainian citizenship in Donbass, in the occupied territories? Nowadays, because if you have this principle, are they still Ukrainian citizens? What is happening now?
Now in temporary occupied territory for Russian Federation, it's a lot of people who acquired the Russian citizenship under compulsion.
Because you are saying to us that Russia compulsory extended Russian citizenship to them. So they were deprived
citizenship
of the Ukrainian citizenship. The Parliament of Ukraine is going to reform legislation concerning single citizenship principle. What are you going to do?
Now, Parliament of Ukraine, in first reading, we are the law about double or multiply citizenship in Ukraine. This was 17 December of 2024. It is the key priorities of the President of Ukraine, Volodymyr Zelensky.
Okay.
Now.
Because otherwise you would lose 7.5 million of Ukrainians.
Yes.
So it's a very big issue. And what about naturalization? So that is the big issue for Italy nowadays. Is it regulated in Ukrainian legislation? Naturalization?
In Ukrainian legislation, we have the right about naturalization. This is Article 9, and after the request and after the requirements.
Which are the requirements for naturalization?
These are recognition of Constitution of Ukraine, submission of declaration on the absence of foreign citizens, permanent residence in Ukraine under 5 years.
So in Ukrainian legislation, the period of residence is shorter than the Italian one because it's only 5 years.
Only 5 years, no, not like 10 years.
And is it required a sort of evaluation of the good character of the person or not?
Yes. In Ukraine, we are existence of the legal livelihood and speaking of Ukrainian language.
The knowledge of Ukrainian.
Yes, a knowledge of Ukrainian and Constitution of Ukraine.
Yes. Okay, thank you very much, Maria. And now we go to Africa. So let's see which are the main features of some of the legislation of some African countries. You've chosen freely, no, to analyze a specific state of Africa, and there are reasons for this, no, aren't they? I think it's time to start with Ivory Coast. Why did you choose Ivory Coast? No. In your analysis on citizenship?
I think it's important to talk about citizen in Ivory.
For you, it's important because you are Ivorian.
Okay.
So demonstrate to us that is important for everyone.
Yes, historically, we all know that Ivory Coast was marked by the French colonization, and in this period, the country was totally subject to French law. So the nationality of all inhabitants was governed by French nationality
The French
code.
nationality
Yes.
code.
And then after independence in the years 1916, we adopted our own code, the first one, strongly inspired by the French model, with the combination of jus sanguinis and jus soli. Jus soli to give the opportunity of the child born in Ivory Coast by foreigners' parents to get automatically this legal status.
Okay.
But,
And do you have some provision also in the constitution, no? Or don't?
No.
No.
Our constitution don't talk about the different mode of acquisition
of
or
citizenship.
yes, but we just focused on the nationality code of Ivory Coast.
Did you reform your legislation over the years?
Yes, we made a lot of amendment of the first legislation. The first one due to a social-political issue in Ivory Coast, because in fact nationality has become a sensitive issue in Côte d'Ivoire in the years 1919 to
And
2000.
why there is this sensitivity for acquisition of Ivorian citizenship?
Because of some tension around some specific notion called ivoirité.
Iwarite.
Yes,
What does it mean, Iwarite?
It's some debates focused on the nationality, the national identity and membership criteria, often linked with the migration issue and the political rights.
Okay.
So on the political field, ivorité means to be exclusively Ivorian by
Ivorian.
blood.
By blood.
Yes.
And what is the implication of this when it comes to the legal status of citizens?
So, firstly, I think the rise of this concept has excluded the principle of jus soli and made the place to jus sanguinis.
So the legislation start to focus more and more on jus sanguinis.
Yes.
And what about the legal status of citizens? Is there a distinction between citizens by blood, jus sanguinis, and citizens acquiring nationality through other means, through other ways, like naturalization, for example?
Okay, in this context, you can say that Ivorian nationality codes establish one of the fundamental principles, equality of rights between citizens by origins and citizens by naturalizations. There are the same subjects of the duty. To justify these points, you have to choose Article 42 in the codes. These articles provide an individual who has acquired the Ivorian nationality shall, from the date of these acquisitions, enjoy all the rights attached to the statute of Ivorians. So when you look closely in Article 43, we see that there are some exceptions.
There are exceptions. Which are those exceptions? Tell us, please.
There are 3 exceptions.
3 exceptions.
For certain periods, he may not be invested electoral functions.
So you mean there are exceptions for naturalized people?
Naturalized people.
So limitation of legal capacity are there, no?
Yes.
Yes.
The period of 10 years, he may not be invested electoral functions. And for the period of 5 years, he may not be a voter if the status of Ivorian is necessary to be registered in the roll.
So I mean, there are. You're saying to us that there are limitations as for political right, enjoyment, exercise of political rights.
Yes.
And are there other kind of limitation apart from this? So other.
For the period of 5 years, he may not be appointed in the public functions regulated by the states. Moreover, in other countries, like Ivory Coast, acquisitions of nationality is not immediately definitive or absolute. You can lose it in certain circumstances or case with commissions certain facts.
And this is always for naturalized people. So there is a legal status that faces some limitation of capacities, and there is also the possibility to lose
It.
Nationality.
With
For fraud.
The use of fraud procedures during the procedures of naturalizations in accordance with Article 65.
And if you commit a crime,
Yes.
also?
Yes. This concerns Article 54.
Okay.
And you can lose it voluntarily. This concerns Article 48, 49, 40.
A lot of articles.
So
You have the establishment of equality, but then a lot of exceptions
Yes.
for naturalized people.
Yes.
And this is not similar in Italy. In Italy, there are not so many differences, apart from maybe one. Lisa, what do you think?
Okay.
Revocation.
Yes.
Because we have also revocation of nationality
Yes. Since 2018.
for
yes.
certain
But
citizens.
for acquired citizens.
For those who are not citizens by blood.
Yes.
Mhm.
All
So
the
this is
categories. So we don't make a distinction
we
between
broke,
naturalized.
so basically we broke this idea of equality when we introduced the specific norms on revocation. Okay.
yes, it's necessary for us to specific these points because there are the exceptions in the revocations. If these revocations should render people stateless, you can.
Okay, so this cannot be applied. Yes, this is correct.
There are the times and the periods to apply the revocations because prescriptions.
Okay, thank you very much. Do you want to add something about Ivorian legislation?
Okay, I present the nationality acquisition by naturalization. And
Yes. So you studied carefully all the criterion that are required to access citizenship by naturalization. Which criterion do you have there in Ivory Coast?
Ivorian naturalization is granted by decree after investigation.
After investigation.
It cannot be obtained without habitual residence in the territory at the moment the decree is signed.
Okay, so there is a need to prove that you have always resided there and that you are still residing in Ivory Coast.
The foreigners who request the naturalization can prove their habitual residence in the territory during 5 years preceding their submission. And the foreigners, it's possible to be with us of 2 years if the foreigners born in Ivory Coast or married Ivorian woman.
Okay.
And if the foreigners has rendered an important service of the state.
Okay. Thank you very much. Thank you very much. And now we go to another side of the African coast, to the other side of African coast.
side.
Where are we going to now?
Now we're going to Mauritius.
To Mauritius. And why?
Because I'm Italo-Mauritian. I have
Okay.
Mauritian origin, so it was interesting for me to study, in this case, my other nationality.
Okay. And so, can you tell us if history influenced the legislation on citizenship in Mauritius?
Yes, a big part of the citizenship legal framework is actually influenced by the decolonization from the United Kingdom, especially Chapter 3 of the Constitution of Mauritius study the recognition of the new citizens of Mauritius after the independence in 1968. And then we also have the Mauritius Citizenship Act in the same year that was recently amended in 2022.
So there is this heritage of English legislation. And do you still face issues concerning the relationship with the UK?
Yes, the relationship with the UK is still ongoing, because the United Kingdom, after the independence, decided to keep the sovereignty over the Chagos Islands, and the negotiations are still very ongoing at the moment. Because recently they decided to end the Chagos Islands to Mauritius, but keep Diego Garcia, which is the main island.
But what is the implication for citizenship?
Yes.
I don't understand it. Can you explain to us?
The implication is that at the moment citizens cannot go and live on the Chagos Islands because it's still under the British sovereignty. So in this case, by incorporation of the lands, there's going to be the possibility for a lot of citizens to go and live again on those territories.
So territorial issues are linked to citizenship issues.
Yes.
There. What about the issue of equality? Like we discussed that in Ivory Coast there is a big distinction between Ivorian by origin, Ivoirité, and access through naturalization. He described to us very well that there are limitation of legal capacity. Is it the same in Mauritian legislation? Are there distinctions between citizens due to the way in which they acquired citizenship?
Yes, definitely. I would say that the main principle is ius sanguinis, as in the other.
As on all the countries
yes, in all the
analyzed.
countries that we analyzed, and also I would say that there are more privileges and rights recognized to citizens by blood compared to citizens by naturalization. Mainly, for example, a good example is that only citizens by blood can get access to dual citizenship, while it is prohibited for naturalized persons who have to renounce to their original citizenship before acquiring the Mauritian one. Just to make an example.
Okay.
And also...
and what about the way in which you can become Mauritian? So through naturalization.
Yes, okay. So in this case, the ministry can grant the certificate of naturalization to a foreigner or a British protected person of full age and capacity who meets certain requirements, such as good character, a good knowledge of English or other current languages in Mauritius, like French and Creole, and a minimum residence period of 5 years.
So there are similarities with Italian legislation.
Yes, yes, there are some similarities,
but
of course the residence period is
shorter.
Yes.
And are there specific norms for people very, very rich?
Yes. Thanks to an amendment dated 1999, investors who invest at least $500,000 in Mauritius can get citizenship after only 2 years of residency. So
there is a very strong facilitation for people who want to invest there,
yes,
build their economic activity in Mauritius. Okay, so thank you very much for your discussion concerning Mauritius. And let's go back to the other coast again of Africa, Lisa.
Yes, okay.
Because you've chosen to study a very tiny place, you call it, no? The tiny country.
The tiny continental country.
The tiny continental country. What is this state that you want to study? The Gambia. So I've chosen the Gambia. Okay. Which are the main characteristics of Gambia, the demographic characteristic, land?
It's a very tiny place, it's a country that it follows a river, basically, within the Senegal.
It's on the river.
Yes, up and down this river, the Gambia River, and it's surrounded by the Senegal and access to the Atlantic Ocean. It's a tiny place, but
how many
crowded.
people? How many people live there?
Less than 3 million, but it's very crowded in certain places. So it was very interesting because even the Gambia was a former British colony. Mm-hmm. So shares some different features with the Mauritian island, but there are also quite similar with Ivory Coast and some specific feature of this tiny
Which
place.
are the specificities of Gambia?
Okay. Well, first of all, it relies on a pure jus sanguinis criterion. So this means that there are some problems with the rights of children, basically, and issue about statelessness, because obviously if you don't allow ius soli even only for
like the Italian legislation, because in Italian legislation we have ius soli to avoid statelessness, as you said.
So, for example,
and in Gambian legislation, it's not like this.
No, it's not like this.
Because if you're born in Gambia and your parents are unknown and you don't have any nationality, you don't acquire.
You don't acquire a
Gambian
automatically.
nationality.
No.
In Italy, instead, you become Italian in such cases.
Yes. Then there are another interesting features is that it's similar. I think this is the British heritage that basically divided into automatic acquisition of citizenship, that is by blood and descent, basically, in this case. And then we have entitlement. By registration is a registration of a right. Marriage, for example, in those system, at least at the beginning, was a right. Okay. Nowadays, I don't know if it is so a registration, so an entitlement, but it's something different from the naturalization, which is a concession, like in Italy.
Like in Italy.
Yes. So, and you can obtain citizenship by naturalization following certain requirements. And
which requirements?
15 years of...
so it's longer than Italy,
yes,
a period that is longer than Italy. So it's harder to be naturalized in Gambia than in Italy.
Then another criterion is that you have to prove, to show that you will keep residing permanently in the Gambia.
Otherwise, you will not be naturalized.
No.
So it's very, very hard.
Yes.
It's very difficult.
Then we have good character, like in Mauritian case. And good character can be proved by certificate of the police, by the police, basically, because it's sort of criminal records.
You have to prove a sort of minimum income,
yes, minimum income for you,
so that you are not a burden for social services. Basically.
And then the interesting thing is, for example, the president can be only Gambian citizen by blood, and cannot have dual citizenship.
So there are limitations to access to the possibility to become president. Okay. So thank you very much for your discussion. But it is clear that at this point, issues concerning citizenship are connected to the historic heritage of the country and to specific problems that each country has to face. It is curious, but in Africa there is a very, very strong connection with history and decolonization, and a sort of imitation of patterns that were present in legislation of France, of UK, that were, in a way, exercising sovereignty on those territories before. So thank you very much, everyone, for your effort to explain some specific aspect of the legislation of some countries, and I'm very, very happy about what we have done here.
Thank you.
Thank you.